10 seconds, 5 seconds, start. We have heard learned counsel appearing for the parties. The learned counsel appearing on behalf of the appellant point out that under section 20 of the Kerala Rent Control Act, the High Court in its revisional jurisdiction cannot act as if it is a second court of first appeal by setting aside findings of fact by the appellant authority on reappropriation of the same. He also argued that there being no perversity on the detailed findings given by the appellant authority, the High Court exceeded its revisional jurisdiction in interfering with the same and wrongly substituting the findings of the trial court for those of the appellant authority. Learned counsel appearing on behalf of the respondent, however, relied strongly upon the trial court's judgment and stated that the appellant authority perversely detailed with material facts on record and its judgment was therefore correctly set aside within the revisional jurisdiction by the High Court. He relied upon the judgment in Badrinarayan Chunnilal versus Govind Ram Gopal. Section 11(8) and Section 20 of the Kerala Rent Control Act are set out here and above. A landlord who is occupying only a part of a building may apply to the rent control court for an order directing any tenant occupying the whole or any portion of the remaining part of the building to put the landlord in possession thereof, if he requires additional accommodation for his personal use, provided that in the case of an application made under subsection 8, the rent control court shall reject the application if it is satisfied that the hardship which may be caused to the tenants by granting it will outweigh the advantage to the landlord. In cases where the appellant authority empowered under section 18 is a subordinate judge, the district court, and in other cases the High Court may at any time on the application of any aggrieved party call for and examine the records relating to any order passed or proceedings taken under this act by such authority for the purpose of satisfying itself as to the legality, regularity, or propriety of such order or proceedings, and may pass such order in reference thereto as it thinks fit. The cost of and incident to all proceedings before the High Court or District Court under subsection 1 shall be in its dissection. It is important in cases like the present to first keep in mind the parameters of the revisional jurisdiction of the High Court. In Hindustan Petroleum Corporation Limited versus Dilbahar Singh, a reference was made to a 5-judge bench of this court by a reference order dated 27th August 2009, which reads as the Learned Counsel for the appellant has placed reliance on a three-judge bench decision of this court in Rukmani Amma versus Kalyani Amma, wherein Section 20 of the Kerala Rent Control Act was in question. It was held in the said decision that though Section 20 of the said Act provided that the revisional court can go into propriety of the order, but it does not entitle the revisional court to reappreciate the evidence.